So this is an episode of Scott Talks Law, and welcome back to another episode of Scott Talks Law. So in this episode, we're gonna talk about the topic of labor dispute resolution and industrial action. So the previous episode, we did an introduction to this same topic of labor dispute resolution and industrial action, but we didn't conclude talking about the entire topic, especially under dispute resolution and industrial action. So we talked about industrial relations and relationship that exists within an employment sector, an environment that consists of employee and employer and trade unions, the relationship that ensures cooperation among members to ensure that they meet their commonality or community of interest or mutual development, that relationship that demands that all disputes should resolve so that that peaceful environment is created to ensure that members are able to meet their needs or mutual development. So under dispute resolution, we talked about the types of disputes, the interest dispute and the right disputes, and we didn't talk about the mode of solving these disputes. So under that environment, disputes can arise, and to resolve these disputes, there are various modes of resolving those disputes. So the Employment and Labor Relations Court, the ELRC, is the court that is mandated or has that jurisdiction of resolving issues to do with employment. So before going to court, there are alternative forms of dispute resolution. And these are forms like mediation, arbitration, conciliation, and we're going to talk about conciliation, which is the main form of dispute resolution under this labor dispute resolution. So under conciliation, a matter shall be reported to the minister, who shall appoint a conciliator within 90 days. So a matter is reported to the minister if it concerns the dismissal of an employee or a termination of an employment contract. So under those two scenarios, that matter shall be reported to the minister, who shall appoint a conciliator. And a conciliator is a public officer, and a conciliator can be someone also who has been selected from the Mediation and Conciliation Commission or the Conciliation Committee, just a recruit from that Conciliation Committee. So the conciliator shall come, and conciliator has got some powers, and the conciliator's powers are to mediate, try and conduct a fact-finding exercise, and try to give recommendations after hearing that particular matter. So for the purpose of coming up with the solution to that particular dispute, a conciliator is supposed to summon parties involved in that dispute. And these parties, after being summoned, they will enter into appearance, they provide any relevant required document or information, and they are supposed also to answer any question that is required from them. So a witness shall be paid by the minister. Any witness who feels like he wants to appear within that conciliation, that witness will be paid by the minister. So we have got under section 68, we have got disputes that are resolved under conciliation. So this is just a mode of resolving disputes. So after a dispute has been resolved, that dispute shall be noted down or written, and shall be signed by the conciliator and the parties. Both parties shall sign that they have they have resolved that particular dispute. So we've got under section 69 unresolved disputes under conciliation. If at all those disputes have gone through a conciliator and a decision hasn't been, the agreement hasn't been reached between the parties are still disagreeing, then that matter shall be recommended to the Employment and Labor Relations Court, which happens to be the court with the jurisdiction to hear and determine cases relating to employment matters. So the court shall hear that case and come up with a decision. So before going to the Employment and Labor Relations Court, there is also an alternative of strikes and lockouts. So that is under industrial action. So under industrial action, strikes and lockouts shall come in, and strikes and lockouts is also another mode of just pushing these employees to make what is necessary for the employers to make provisions for the employee, or just to give them what is theirs. So we have got circumstances that can allow strikes and lockouts, and these are circumstances when terms and conditions of employment have not been met. Then strikes and lockouts can be permitted, or when there is a written notice within 7 days permitting that strikes and particular strike and lockout, then those people shall go for strikes and lockouts. So the minister gives them that notice for strikes and lockouts. So we have got prohibited strikes and unprohibited strikes. Prohibited strikes are those strikes that are to register trade union. You cannot strike for the registry of a trade union. That cannot happen. Prohibited. So those are just most coming up with solutions to disputes. After coming up with those solutions, then we go back to cooperation, and these members will then continue meeting their mutual development. So that is the end, and stay tuned and have a nice day.